Okay, thank you very much. Next case on the docket is VANDYKE versus VANDYKE. All right, appellant may proceed.
Good morning, Your Honors.
Morning.
Richard Feinberg for the appellant, Kurt VANDYKE, who's present before the court. I would also like to reserve 3 minutes for rebuttal as well. The case below involves a domestic family action from Brevard County. The case was tried by the Honorable Lisa Davidson over a 3-day period, April 13th, 14th, 15th, 2010. The case involved issues of equitable distribution, alimony, time sharing with children, child support, and attorney's fees. A final judgment was entered by the court, by Judge Davidson, on July 7th, 2010. The husband timely filed a motion for rehearing on July 16th, 2010. The trial court denied same without a hearing on August 16th, 2010. The motion for rehearing addressed the following issues. Number one, whether or not the amended Florida statute 6108, which included durational alimony and made other changes to the alimony statutes in Florida, should have applied to this case. Number two, the court's failure to consider the testimony of the husband's vocational expert, Ellen Fernandez. Number three, whether or not it was error to award permanent periodic alimony in light of the deficient findings as to need and ability. Number four, address time-sharing issues, which is not before the court this morning. And number five, the husband then filed his timely notice of appeal on September 13th, 2010. Subsequent to that, the court entered an addendum to the final judgment awarding $4,500 in attorney's fees to be paid at $150 per month. The husband doesn't necessarily challenge the amount in the addendum because that did come after the notice of appeal was filed.
Now, the trial court rejected the argument that the July 1, 2010 statute should apply on grounds that she held a hearing, was prepared to issue the order before July 1, 2010, but counsel below for your client said, no, I need some more time, and if you delay issuing the order, I will not raise that issue at all. Correct? That was the basis for her denial.
Well, I'm not quite sure that the trial court, Your Honor, ever denied the application of the new statute. There were more proceedings.
Was that the trial court's finding or not?
There was no finding. There was no finding.
Trial court never said that?
The trial court, in a transcript dated July 23rd, 2010, had a telephone conversation at which there was a court reporter between Walter Rose, who tried the case for the husband, and Mr. Brewer, who was trial counsel for the wife. The telephone conversation began by Judge Davidson speaking with Mr. Rose and asking him whether or not he ever indicated to the court that he had waived the application of Florida Statute 6108 as amended July 1st.
Well, what did the trial court say about that?
The trial court's recollection, and again, the problem, Your Honor, is there's no court order and there's no finding.
What did the trial court say about that?
The trial court's recollection was that Mr. Rose had waived the application of the new statute. That, in fact, as Judge Lawson has indicated, that he needed additional time to review a draft of the judgment that Mr. Brewer had prepared.
If that's the case, then it would have indeed been improper to raise that issue, right?
I don't believe so.
Waived, right?
I don't believe so, Your Honor, because I don't think that there was any knowing or consensual waiver by Mr. Rose. This would have required an evidentiary hearing by the court.
Why wouldn't it be why wouldn't he be barred from raising the issue on a theory of invited error or estoppel? I mean, I understand that with respect to waiver, there's some issues about, but I mean, clearly if the judge said this is what happened on the record and you don't have anything to the contrary, I don't know why that wouldn't be an invited error or an estoppel.
I don't believe that it's invited error because I think in terms of the July 23rd hearing, the court needs to look at the hearing that also occurred on June 10th, 2010, and the memorandum that was filed by Mr. Rose on July 19th, 2010. In the transcript from June 10th, 2010, there is approximately 7 or 8 pages of discussion between the court. It's pages 12 through 18 of the transcript from June 10th, 2010, which is part of this record, where the court, Mr. Rose and Mr. Brewer, are all discussing the new coming statute. It's clear that they're discussing it. They're talking about a change in the alimony. They're talking about whether or not it should apply to this case, but there's no ruling by the court. There's no finding that it does apply, doesn't apply. There's nothing addressed by
At the July 23rd hearing, the trial judge said, I know what happened. I made a telephone call. The only uncertainty expressed was whether it was on the 29th or 30th. She said, my memory's shaky whether it's 29th or 30th, but I was going to enter the order before the new statute came to effect. But counsel said, no, I need more time, and I won't raise the issue. To me, that sounds like a clearly a case where judicial estoppel should apply, or where if there's any error, it's invited.
The gist of that hearing, Your Honor, you're absolutely correct. July 23rd, but however, Mr. Rose said, I don't recollect ever making such statement. He denied making such statement. And clearly, under the cases cited in our reply brief, there was no evidentiary hearing, no finding that Mr. VANDYKE had ever consented to Mr. Rose or given Mr. Rose that authority to waive the application of that statute. In fact, if you read the transcript, it appears that the telephone call initially...
But as of the date that conversation, the judge said, I know this conversation happened, he didn't have any right to waive. I mean, she could have entered her order then and there would be no question the prior statute would apply. He wasn't waiving anything. She was just going to act, and he said, no, don't act, and if you don't act, I won't make it an issue. So she delayed.
I agree. She did. She could have entered the judgment June 29th, 2010, and whether or not the statute effective July 1st, 2010 would have applied would have been a moot point. But she didn't. She entered it on July 7th. And therefore, Mr. VANDYKE feels that if there was any invited error, it was as much invited by the court as it was Mr. Rose, that Mr. Rose did not have any authority from Mr. VANDYKE. There was no record of this telephone call. This is purely recollection of a trial court judge and 2 counsel nearly 1 month after this purported telephone call took place. Mr. Rose's recollection was very different than the court. Mr. Brewer's recollection was similar to what Judge Davidson's was. Moving on, beyond the application of 6108, we feel that the new statute should have been applied. We feel that this is a classic case of durational alimony. We feel that based upon the language of the statute, which says that it does apply to all cases pending on or after July 1st, 2010, the court should have applied the amended statute 6108. We also feel that even if we're traveling under the old 6108, that what Judge Davidson did here was not a proper alimony analysis under 6108. If the court looks at the transcript, the excerpt as well as the entire trial transcript, from the ruling portion on April 15th, 2010, the court goes through a 2-page alimony analysis found at pages 25 and 26 of the excerpt. The court does not discuss the wife's financial needs. The court does not discuss the husband's ability to pay. In fact, nowhere in the court's analysis do the words need or ability appear. She goes through the comfortable lifestyle, talks about the parties' ages and health, and talks about their employment. And then the court says, and therefore I'm going to order $1,200 a month in permanent alimony, without any basis, without any analysis. If the court then looks at, and part of the problem that Mr. VANDYKE is complaining about, several pages later in the same transcript, on page 28, lines 14 through 19, Judge Davidson states, I'm not doing that. He's going to pay the alimony to her she's going to pay the child support to him. I'm saying when you start netting at the end of the month, it's not as horrendous as Mr. VANDYKE looked. And I would suggest to this court that netting at the end of the month is an improper alimony analysis. And it's very clear from this record that that's what Judge Davidson was doing. If you look at the hearing that occurred before the court on June 10th, 2010, that I referenced earlier, specifically pages 47 through 51 of that transcript, where Judge Davidson undertook to take unsolicited, unsworn testimony from Mr. VANDYKE in the middle of argument between counsel, Judge Davidson, at page 47 of that transcript, states the court, Mr. Brewer, in all honesty, when I did this, referring to the alimony award, I really thought she was going to pay $700. She repeats that, the court repeats that on page 48, at the bottom of page 48 onto page 49. Again, the court states, but when I gave the $1,200, I really thought she was going to have to pay $700. And I did say that to him. The court states it again at the bottom of page 50 onto page 51. The court, I mean, just really, when I did that at the trial, I felt that she was going to pay him child support. And if you read the rest of the transcript...
Let me ask you, what about, I mean, in the final judgment, the court said, the order reads, the court has considered the factors set forth in 6108 makes the following findings, and then there are specific findings relating to alimony. Now, they don't include financial resources of the party, but then in the different section on the assets, I mean, it's clear from the final judgment that she considered the assets of the party. She deals with them in there. So I don't see that it appears from the final judgment. She says she considered all these things and she makes findings of fact.
She did. She went through most of the statutory factors. What she didn't conclude or what she didn't analyze is whether or not Ms. VANDYKE had a need, and more importantly, whether or not Mr. VANDYKE had any ability to pay. There is no analysis on that at all. The court paid lip service to these statutory factors and did not get down to the nuts and bolts of finding need and ability to pay. There's additional authority for this proposition. Very recent cases out of the 2nd District, not in our brief. I would cite the Kennedy case, 60 Southern 3rd, 466. It's a 2nd District case from April of 2011. And the Kennedy case, also from the 2nd District, 62 Southern 3rd, 672. It's from May of 2011. The Kennedy cases the language in the Kennedy cases is particularly important in this case, and they say that a court's discretion whether to award alimony is at its broadest when they're talking about a gray area marriage. And if you look at the case law over the 20-year period of time that we had gray area marriages, if you were married anywhere between 11 and 13 years, had 2 kids, the husband earned $60,000 to $80,000, and the wife was making $15,000 to $30,000, you could walk into any circuit court with 20 different judges and get 20 different rulings, all the way from perhaps some rehabilitative alimony to permanent alimony to nothing. And bridge the gap alimony didn't exist in this district until just several years ago. The cases were all over the map, and they were off the charts. And that's part of the reason why the legislature amended 6108 and gave us the durational alimony. But in the Kennedy case, the court is saying the trial court's discretion is broadest when it's applied to a gray area marriage. For that very reason, the court's consideration of the statutory factors and its findings in regard to them are most important in these gray area marriages. Oddly enough, in this case, they cite the new 6108, which was enacted after the effective date of this case, but they steer the parties to this. The court then goes on to say, as our Supreme Court observed long ago, the trial court's discretionary power is subject only to the test of reasonableness, but that test requires a determination of whether there is logic and justification for the result. The trial court's discretionary power was never intended to be exercised in accordance with whim or caprice of the judge, nor in an inconsistent manner.
She made all these other findings, and then, I mean, she found accurately that he makes about $90,000 a year, and that she took herself out of the workplace in order to raise their children, to be a stay-at-home mom, that she aided his career in that way allowed him to build the career that he has over the length of the marriage. I mean, so all you're saying is that we need to remand it so that she can explicitly say what's implicit, which is he has the ability and she has the need. I mean, all the other findings are there.
No, that's not my point, Your Honor. My point is, from the two transcripts from April and June of 2010, the court may have addressed those factors. The court may have found what the parties were earning. But then what the court did was the court did a net sum difference of alimony and child support. It's mixing apples and oranges. The court cannot do that. The court said on several occasions, when I awarded $1,200, which was the initial alimony award in this case, I thought she was going to be paying $700 in child support. Later on, it turned out after the parties, through their attorneys, had several other hearings in this case, that applying the gross-up method of calculating child support, not only was it...
If we determined from looking at the entirety of the judgment and the record that the trial court really, in essence, did consider need and ability, but just didn't specifically include that in the final judgment, why wouldn't that be harmless?
I think if you could look...
I mean, that's their basic argument in their brief.
That's counsel's argument. Read between the lines. All the findings are there. It's sufficient. You should be able to look at this judgment, read the record, and determine whether or not the court did the appropriate thing. But I'm suggesting that if you do that and you read all these transcripts and you see what transpired from April 15th all the way to July 23rd, this judgment was never final. This alimony concept was entirely fluid. It was constantly subject to change. And if it was subject to change, where's the analysis of need? How can you do that? How can you just take a $1,200 number and reduce it to $800 based upon unsolicited, unsworn comments from the husband at a post-trial hearing? How can you do that? There's nothing in Chapter 61 or the Evidence Code that permits that. And doesn't that lead us to believe that the underlying analysis is incorrect? What is it based on? What is Mr. VANDYKE supposed to say to himself that this alimony award is based on what? It's based on whim, capriciousness, and arbitrariness because it was reduced at a hearing that had almost nothing to do with that issue.
3.5 minutes left.
I would like to just address for 20 seconds, Your Honor, the issues of the courts not taking into consideration the vocational evaluator's testimony. There are significant portions of the record where the vocational evaluator talks about judges as a surgical technician, talks about employment opportunities as a surgical technician and a massage therapist. The testimony was all present at that point in terms of wage earning ability, positions.
It seems like the way I read it, she considered it and viewed it as consistent with the wife's testimony. He testified that there were some jobs, not a lot, but some jobs in that field, that there were a lot of people applying for those jobs. She had applied for them, and because she'd had no experience in a significant amount of time, she'd been out of the workforce, she couldn't get any of those jobs. I mean, so she imputed minimum wage. That seems like she considered that testimony.
I think that there is not competent substantial evidence to support Judge Davidson's decision on that. And if the court reads the transcript and reads the testimony of Ellen Fernandez, I think the court will conclude that...
Why isn't the testimony that she has a certificate that would allow her to meet the minimum qualifications for a job, but that it's very competitive and she can't get a job in that area, be a sufficient basis not to impute income at that higher level? Because
I think based on the testimony, there were multiple jobs. There wasn't a paucity or a scarcity of jobs. There were multiple jobs at multiple hospitals. In fact, even during the trial, Mr. Rose recalled Ms. Fernandez, who continued to do ongoing research, and she testified that there was a hospital in the Central Florida area that had 4 positions open as of yesterday, was her testimony, as of the day that she testified. I think the court did not pay any attention to that testimony, and I think the court's finding on that testimony is not supported by the record evidence. Finally, and I realize I'm down to 1.5 minutes or so, on the issue of attorney's fees, this case issued an opinion in Noggle, and there's no question that at the end of this trial, Ms. VANDYKE received $100,000 in assets, approximately $22,000 of which were cash. Mr. Van Dyke had to borrow money against his 401k to get the cash to pay Ms. Van Dyke. Judge Davidson ordered that payment within 60 days of the final judgment, even though there was absolutely no evidence before the court that there were any liquid assets in this divorce other than a bank account with a very small amount of money. These parties, if not on similar or equal financial footing at the end of this case, I would submit that Ms. Van Dyke, because of the virtue of the fact that she received a large portion of the 401k, a large portion of an IRA, and I understand there are tax consequences to tap it, but there would be for Mr. Van Dyke. He testified that he borrowed $29,000 to pay his own attorney's fees, or would not have had the ability to pay them himself, and Ms. Van Dyke left with cash of nearly $22,000. Mr. Van Dyke left with nothing. And I think that, again, the court paid lip service to the words need and ability, which were found in the final judgment, without any supporting competent substantial evidence. And I'm out of time. I thank you very much for your time this morning.
Good morning. I'm Stephen Brewer. I represent Dawn Van Dyke in this matter. You've kind of made all of my arguments. With regard to the waiver, I believe you're absolutely correct with the way you've recited that. The judge was prepared to render the final judgment on the 29th. He argues the hearing on the 10th where that statute was raised. That's precisely why the judge was ready to enter it. She was well aware of it. She didn't want it to apply to this case. It hadn't been tried under the circumstances of that statute. At the conclusion of the trial on the 15th, she did a somewhat unusual thing for a trial judge, is that she rendered some rulings. She didn't rule on everything. She rendered some rulings. She rendered a ruling as to the alimony and some of the other things. She then directed both attorneys to prepare proposed final judgments, email them to her. She was then going to go through them and create her own, and that's exactly what she did. She then sent it out to the two attorneys after she had combined it and asked for comments. We both made our comments, and that's what resulted in the hearing on June 10th to reconcile those. A final judgment was then directed to be prepared by myself. It was submitted on the 29th. The judge was ready to enter it at that time. There is in the appendix that the appellate included an email or fax from Mr. Rose that he was in North Carolina on vacation requesting to be delayed, that entry, because he hadn't had a chance to discuss it with his client. And that's what prompted the telephone hearing, which was precisely as Judge Davidson had represented. She asked Mr. Rose about the statute. She says, I'm prepared to enter this now unless you agree that you're not going to argue the statute. And he, in fact, said he waived it on that basis. I don't think they have an argument that he needed his client's consent, because if he'd said, I need my client's consent, she was going to sign this final judgment at that particular time. So I don't believe that's an appropriate argument to be made. So I believe that that in fact was waived, and the considerations of the new statute were not to be included in the judge's decision in that particular case. I did want to talk a little bit about the need and ability to pay argument. I think everything that the judge does show the court that she made those considerations. At the time that she rendered the ruling as to the $1,200 per month, no one had done a child support calculation. We were right at the threshold of that was back when there was a 40% gross up method. We were right at that threshold. I don't believe anybody really understood. She hadn't fully rendered her ruling as to the time sharing, so we didn't know. I think her considerations of lowering that amount show that she considered the needs. She had an idea of the needs and Mr. Van Dyke's ability to pay. When she said $1,200, she thought my client was going to have to pay $700 in child support. So she knew an amount that she wanted that Mr. Van Dyke would have to pay, and an amount that my client would consider. So certainly she was considering those needs. All of those needs were before the court. The financial affidavits were in evidence, everybody's needs and the different amounts of income. So I believe that was clearly considered. If you look at the child support section, and Your Honor raised the issue in other sections, you can surmise certain things. You look at the child support section, it shows that Mr. Van Dyke ended up with over 72% of the combined net monthly income, whereas my client only had about 28% of the combined net net monthly income. So certainly, certainly she considered those particular needs. It seems like they want it to go back to the 1,200. I'm not sure their argument there. We'd certainly be glad to do that, but what the judge did do, once we submitted those proposed final judgment, we submitted child support guidelines which showed the amount of child support that would be involved. Once again, we argued in our brief and talked about magic words and need and ability to pay. I don't believe that those are required. You certainly can surmise that just based on looking at these parties' incomes and the difference in the incomes after the award of the $800 per month alimony. The last thing I want to, certainly he talked a lot about discretion and the judge's discretion, and certainly the Judge Davidson has the discretion, did not abuse her discretion in awarding permanent periodic alimony under the circumstance of this case as she outlined. Mr. VANDYKE getting 2 master's degrees during the marriage, advancing in his career, having a secure job, my client being out of work for almost 10 years, out of the field of surgical tech, and not being able to get a job. That brings me to the last point that he raised about the vocational thing. The testimony is clear that my client applied to 18 hospitals in the 2 months leading up to the trial. All of the hospitals that had been represented by the vocational evaluator that had particular jobs. The vocational, every one of those she'd applied for, she testified to the method, and the court is probably aware of the method anymore. You don't send out resumes anymore. You apply online and you wait. There's no way to follow up. There's no way to check. My client testified to that procedure and how that's particularly done in this case. She testified, Mr. Rose, for some reason, the last day of the trial, recalled his vocational tech who came back, or vocational expert, and said there was 1 job available in the county. 1 surgical tech job at Wusthof Hospital. My client had testified she'd already applied there 3 weeks. She had a resume on file and received no call. That particular job was a part-time per diem job. So we believe it was more than appropriate for the court to impute the minimum wage and not impute any additional incomes to the parties. On the issue of attorney's fees and costs, most of it was cost, but $3,000 in attorney's fees was about 1/4 of the attorney's fees in this particular case. And under the circumstances of Mr. VANDYKE having 72% of the combined income and my client having 28% of the combined income, that seems more than appropriate based upon each of them on his ability to pay and her need for some contribution towards attorney's fees. I would rely on my brief for anything else if you have any questions. Thank you.
Okay, thank you very much. All right.